Estate disputes and prenuptial agreements. Panel discussion of comparing and contrasting Ketubah and a domestic contract.
What we're doing at the moment is we're going to have a panel discussion with Rabbi TORCZYNER and Judith about the Ketubah and the domestic contract. Both in Jewish law and in the law of Ontario, there is a way in which each system deals with inheritance. In Jewish law, in accordance with the Torah, there's a forced heirship regime. Under Ontario law, inheritance is either in accordance with the last will and testament of the deceased, or if there is no will, with the law of intestacy. I'm going to pose a series of questions to Rabbi TORCZYNER and Judith. Rabbi, I'm going to ask you to go first in the first one. Rabbi, can you please explain what impact, if any, the Ketubah has on the entitlement of a surviving spouse of a second marriage?
Sure, thank you. And thank you for inviting me to participate. I have to admit it's more fun to be in the comedy part of the program, but nonetheless. The question is the impact of the Ketubah on the entitlement of the surviving spouse of a second marriage. So, as I wrote in the paper, which is in the binder, in biblical times, a man would pay a sum called a mohar upon marrying a woman. It wasn't necessarily a Jewish practice. It was actually found in broader society as well. Within Jewish law, that evolves to become the Ketubah payment, in which the husband incurs a debt to the wife from the time of marriage, but not paid until either divorce or his death. So what happens is the Ketubah document places a lien on his estate at the time of the marriage, as well as on all future income for payment of the Ketubah sum. So the result is that any debts that he incurred before he married her, which will include the Ketubah from the first marriage, predate the lien of the Ketubah of the second marriage, and they have first claim. The Ketubah from the second marriage is going to have prior claim over any will that he writes or any debts he incurs after the date that he married her, so that she'll be protected from anything from the date of the second marriage forward. Now, one note regarding prior wills. If the husband prepared a will during the first marriage, and that will was written as a gift upon his death, as opposed to an inter vivos gift, then the Ketubah is going to precede that will, assuming the will is recognized within Jewish law, which, as you know, is its own topic. But if he writes a will before he marries her, but it's only going to be effective upon his death, fundamentally, the Ketubah from the second marriage preceding his death is going to have claim before that will. The will wasn't written as a debt. Last note, if the second wife knew about a will that preceded her marriage or was written during her marriage, which assigned particular assets to other parties, and she doesn't protest, then it may be assumed that she forgave her claim to that property. I wrote about that more in the paper. But in the event that he has actually chosen to give away, let's take the case that you had and imagine that he had stock shares and he had given them away. If she knew about that and didn't protest, it could be that those would be excluded from the claim of the lien associated with her Ketubah.
But just so we can be precise with terms, isn't it true that for any parting of assets, they would have to be inter vivos during the lifetime? Because by definition, a husband or a man or wife, they don't own things when they die, correct?
You're talking about from a Jewish law perspective?
Yes.
Generally speaking, that will be true.
Okay. All right, I'm going to turn to you, Judy. Can you explain what impact, if any, a domestic contract would have on the right of a surviving spouse in a second marriage?
Okay, so I'm assuming that the domestic contract we're talking about is the domestic contract between the surviving spouse and the deceased as opposed to the first spouse.
Correct.
Okay, so then assuming that we have a valid and binding domestic contract where the formalities have been met, which is they have to be in writing, signed by the parties and witnessed, and also assuming that we've taken the necessary steps to ensure that the domestic contract will not be set aside. So assuming a valid contract, then the property provisions in the domestic contract should supersede any property rights that the second spouse would have under the Family Law Act and also under the Succession Law Reform Act. Now, my understanding in terms of support is that it's because of the provisions of the Succession Law Reform Act, the domestic contract is only one factor that the court considers, so it won't necessarily have an impact on support and whether there's an entitlement to support under the Succession Law Reform Act.
I think you're quite right about that, and there is a specific provision in the Succession Law Reform Act. Not only is it just one factor, but the Act specifically provides that a judge can ignore any domestic contract. Let's go on to the second question, and we understand that the Family Law Act has certain formalities. You mentioned that when you're talking about a domestic contract. Section 55, subsection 1 of the FLA says a domestic contract and an agreement to amend or rescind a domestic contract are unenforceable unless made in writing, signed by the parties, and witnessed. The Ketubah is not signed by the parties. Am I correct, Rabbi?
Correct.
And I'm going to ask the question to both of you, but I'd like to start with you, Judy. Do either of you see any value in adjusting the Ketubah so it could be enforceable in a secular court?
So, in my mind, I don't see any value to doing that. I don't think that that's something that we would want, because it's not only the formality, so it's not only that it would have to be signed by the parties, witnessed, and in writing. We'd also have to ensure that we met the certain provisions of Section 56 sub 4 of the Family Law Act, that if we don't ensure that those have been met, then we would run the risk that the Ketubah would be set aside as any contract would. And those are, and I just have, actually I have the section, so I'm just going to read that. It provides, Section 56 sub 4 of the Family Law Act, that a court may, on application, set aside a domestic contract or provision in it if a party failed to disclose to the other significant assets or significant debts or liabilities, if a party didn't understand the nature or consequences of the domestic contract, or otherwise in accordance with the law of contract. So many of these, in fact, I think all of these would pose a problem for the Ketubah. First of all, understanding of the nature and consequences of the contract. So the first question would be, how would we ensure that the couple would actually understand the Ketubah and what it is they would be receiving under it? I understand, and Rabbi TORCZYNER can speak to this, but there's language of a wife receiving 200 zuz, I believe, and I don't know what that is. I'm not sure if anybody knows what that is. So that becomes an issue. Then in addition to that, the parties would have to understand what would be their rights and entitlement under the Family Law Act, their spousal support rights, their property rights. So it would mean that each party would probably have to go get independent legal advice, which would be a costly endeavor. Also, potentially speak with a lawyer, a rabbi, and have an understanding of what the Ketubah was providing. The next issue is the financial disclosure. And what we do today when it comes to marriage contracts, we actually don't just have a Schedule A and B. We actually have each party complete sworn financial statements setting out all their assets and liabilities. We'll provide a document brief which has all the backup documentation. I actually, if for example there was a company like we had today, this Schmutta Inc., I would actually go and make sure that there was a valuation of the shares if there wasn't a recent valuation, so that each party would know the exact value. If there was real property, I would have that valued. So there are many things that would have to be done to actually know what the value would be. Generally, we are exchanging income tax returns to also understand what each party has. So the financial disclosure piece, again, who would be ensuring that this was going to happen? Who would be, in charge of this and ensuring that every couple who wanted to be married according to Jewish law had done this? The next issues that we come to, which are the otherwise in accordance with the law of contract, that a contract could be set aside, that's dealing with things such as duress, undue influence, mistake, unconscionability. And when we get to duress, so the ketubah is signed on the wedding day. We family law lawyers always say, really any marriage contract that's signed on the day of the wedding is never going to stand up. So in this case, we're always going to have it signed on the day of the wedding, which would be a significant problem. The other issue with duress is that the parties actually have to sign or they would have to sign this ketubah in order to get married. So the question is, could there ever not be duress if you have to enter into this ketubah in order to get married according to Jewish law? And then the next issue in terms of unconscionability and fairness of the agreement is when we're drafting and preparing marriage contracts, we're trying to ensure that they're tailor-made to the parties. So I don't know in the case of a ketubah if we could actually have it tailor-made or if it's going to be the same amount being left to each person in each circumstance. And if that's the case, then it may well be unconscionable for some people because depending how wealthy the parties are, how long the marriage is, what the parties are doing, it could be that it would be a very unconscionable result at the end of the day to only receive 200 zuz or whatever it might be that's being received under the ketubah. And then I guess my concern is, are we then going to be having, if this was going to be enforceable, generally the way it works is the marriage contract is superseding the rights under the Family Law Act, the rights under the Succession Law Reform Act. So if the ketubah was doing the same thing, then my concern is that we're making every couple who wants to be married according to Jewish law opt out of essentially the legislation and the regime in Ontario. And I actually think that's a bad idea because I think in most circumstances and situations, it's actually good for a couple to be under the Family Law Act, the Succession Law Reform Act, and be receiving their entitlements that way as opposed to opting out of the regime.
Rabbi?
Okay. Judy, thank you. You spelled out many of the issues. I'm going to give a brief rundown of what the problems are with applying the ketubah and then the question of whether it's worth trying to change it. As noted already, it's true, the ketubah, like documents in general in Jewish law, is signed by witnesses rather than the parties themselves. There is the matter of the ambiguity of the ketubah text. There are two currencies mentioned in the ketubah text. One of them is indeed the zuz, and the other is zikukin. So people actually do know what a zuz is. Because if anyone makes it to the end of the Passover Seder, you are familiar with the song Chad Gadya, right? Where you buy the little kid, the young goat. It's a yearling goat, and you pay how much for it? 2 zuz, right? Trei zuzeh. So you pay 2 zuz for it. So basically, if you want to know how much a zuz is worth, it's half of a yearling goat. So if you're getting 200 zuz, 100 little goats. I have a friend who actually checked into this, going to country fairs, and he determined that he thought that 2 zuz was probably about $75. But I imagine that varies in the goat market in various places. I'm not sure if it's indexed to the consumer goat index. In all seriousness, though, there are quantities of silver that the zuz is pegged to Talmudically. There is, I know you'll be shocked, a lot of rabbinic debate as to exactly how we value the zuz as well as the zikukin, and that does create ambiguity surrounding the text. But the ambiguity actually gets worse because there are various responsibilities, and I noted them in the paper that's at tab 8. There are various responsibilities of the husband to the wife which are automatic with the ketubah but are not actually written into the ketubah. So that you're accepting responsibilities that aren't even recorded in the document, and yeah, that's going to qualify as ambiguous. And of course, the issue of disclosure. The ketubah has no requirement of disclosure of existing assets. Yes, one has to be honest. There's a strong biblical prohibition against deception. And in fact, projecting a misleading impression of one's finances will disqualify a marriage. If either the husband or the wife claims to have assets that they don't have, that's grounds for dissolving the marriage. However, active disclosure is not required as long as you don't convey a misimpression. Now, you could solve these problems without necessarily even changing the Ketubah. Many people do have the husband and wife sign on the Ketubah, and that's legitimate as long as it's clear that they're not functioning as the witnesses. So ceremonially, you'll see many people will have a Ketubah in which the husband and wife actually have signed. We could theoretically institute sessions in which the Ketubah is thoroughly explained and a value in common currencies is set for the Zuz and for the Zakukin, and that would solve that problem. In terms of tailoring, you mentioned the issue of tailoring it for the people involved. Theoretically, you can tailor the sums that exist in the Sephardic community more than the Ashkenazi community, but they will change the sums, and if they wanted to specify something, they could do that. The duress issue, I definitely hear the point about the day of the wedding being automatically, duress. On the other hand, I'm not sure if culturally everybody signs theirs that day. I'm not sure, how you'd look at duress, but that's, your field rather than mine. Bottom line, though, is that I think the efforts to adjust the Ketubah and take care of all these problems would not be justified. The primary goal of the Ketubah payment is to ensure the wife's needs are taken care of after the marriage, and today's civil law does that more than adequately. The primary goal of tying the Ketubah payment to divorce is to make the husband think twice before divorcing his wife. And again, today's systems and mechanisms take care of that capably as well. And because Jews get married in jurisdictions around the world, if you are going to start trying to modify the Ketubah and its circumstances to satisfy jurisdictions, you're going to have to take into consideration all the various jurisdictions and societies in which Jews get married to try to meet that end. I don't think it's warranted, and I don't think it'll serve the purpose.
Thank you. Both of you mentioned some very important points, even outside the realm of what you're addressing. The first being, the section you quote in the Family Law Act makes it very clear that you have to remember that a domestic contract's a contract. So whatever law goes into deciding whether or not to set aside a contract applies equally to this. One of the points that you made, which I think is applicable across the board, is that, and I want to make it clear here because this is being videotaped, it's going online, it's going to be seen by people outside of our jurisdiction. The events today and the law today are applicable primarily to Ontario, and where it's being observed by a person in another province or in the United States or another jurisdiction, those laws may be different, and one should be cognizant of that when hearing the presentations. I have a last question to pose to all of you before we go to a panel discussion of all the presenters. You both watched our moot court today, and Rabbi TORCZYNER, if the couple in our case scenario were Jewish, signed a Ketubah, and came before a Beis Din, a religious Jewish court, to adjudicate their dispute, what factors would a Beis Din have taken into dispute in trying to determine how the estate should have been divided?
Okay, so I want to preface my remarks by saying that I am not a dayan, meaning I do not serve as a judge on a Beit Din, on a court. I've studied the issues, but I'm not speaking professionally on this. I'm also going to separate out the Jewish law issues from what we call Dina de Malchuta, the law of the land, meaning I'm going to pretend that this court, this rabbinical court, this Beit Din, is dealing with the case in a Jewish country operating by Jewish laws and not dealing with the question of how they would deal with the intersection between Jewish law and secular law. So it sounded from the statement of facts, although changed a little bit during the course of Erwin's testimony, but it sounded like from the statement of facts, the kids were given the shares in a way that would be accepted as what we call a kinyan, a proper transaction within Jewish law. So Given that, the basic principle in Jewish law is hamotzi mechavero alav haraya, which means if you want to take something away from somebody else, if you want to claim assets somebody else is holding, you have to prove you have a right to it. The person who is holding them is the default. So there are three arguments that the husband might make that I saw to claim it. Number one, disqualifying his agreement from before the marriage under failure to disclose assets, and saying that therefore he never waived his rights and maybe he could claim them as part of the property that she had at the time of the marriage before she ever gave them to her kids. As I mentioned in answering the second question, I don't think that will work because failure to disclose is not an issue within Jewish law so long as you don't present misinformation or a false impression. So therefore the prenuptial agreement would not be disqualified by failure to disclose the assets. The second would be an argument that the waiver of rights to it would be ineffective. The waiver of rights to it would be ineffective, having nothing to do with disclosure, but because the waiver of rights happened at the wrong time. Meaning, Jewish marriage takes place in two phases. The first phase is called Kiddushin. That's when he gives her a ring. There are certain blessings that are recited. And then the second stage is Nisuin, which completes the marriage. Before the Kiddushin stage, before the beginning of the marriage, and this is what happens for the couple under the chuppah, at the very beginning of the chuppah. Before that, he didn't have any right to her property, and therefore he's also unable to dismiss his right to it. He can't waive a right before he actually receives it in Jewish law. It's called davar shelo bala olam. It doesn't exist for him to waive it. And because he doesn't have the ability to waive it at that point, whatever he signed is frankly irrelevant. Parenthetically, had he signed the waiver after the marriage, that also wouldn't work because it's too late for him to waive it at that point. He has already received the right, and this is one of the rights within a marriage that that cannot be dispelled, the right to inherit. He cannot renounce his right to inherit. That's correct. There are certain rights within the marriage, mostly her rights, but in this case his, that cannot be renounced, and that's one of them. So therefore, on those grounds, the argument could be that he had the right to inherit this from the time of the marriage. However, because we're talking about stock, that may not be true. A husband's ability to inherit from his wife within Jewish marriage is specifically for realized property, for property that she's actually holding. In Hebrew, it's called muhzak, something that's in her possession. And you can make the argument that shares of a corporation do not qualify as muhzak. And I'll give an example of this that I hope will be more familiar to people. People are familiar with the prohibition on Passover of owning chametz. We're not allowed to own leaven. What if I own shares in a company that owns leaven? If I own shares in a company that has bread, am I obligated to get rid of my shares before Passover? So in fact, there is such a view that says, yes, I would be responsible to get rid of my shares. That has extraordinary tax complications and so forth. But says, yeah, hypothetically, just like I get rid of my chametz, I also have to get rid of my shares. However, the dominant view, I believe, is that we don't view owning shares as the same thing as owning the property of the company. And therefore, the fact that I own shares in a company that owns chametz doesn't mean that I actually own physical chametz. That's why I don't have to get rid of those shares before Passover. In the same vein, she owns shares in the Shmata Corporation, but that doesn't translate into actual rags or silk or whatever those are. Because of that, he doesn't actually have the right to inherit it. So in other words, his right to inherit his wife's property, I think very possibly does not extend to the shares in the first place. And therefore, the question of whether he waived the right or not actually is not relevant. So in terms of the argument that the waiver is disqualified, the answer is the waiver may well be disqualified, but he didn't have the right to the shares in the first place. In terms of disqualifying the gift to the children as a fraudulent conveyance intended to subvert the FLA, so Jewish law isn't going to care about that as long as the gift is executed properly.
You know what? This is a very complicated answer.
I want you to add one thing, and then we've got to run because
Yes.
we're tight on time. Is there a distinction between the property the wife brings in and the husband's right to inherit it and the usufruct?
Yes.
Okay. Could you make that distinction?
Sure. Usufruct is the idea that the husband has the ability to make use of some of the wife's property in the course of the marriage. And then he's obligated to make sure that that property is whole when the marriage ends and the property reverts to her. That doesn't provide him with right to inherit the property. With the dissolution of the marriage, it goes back to her. To try to simplify what I guess was a little bit of a complicated answer in terms of how I would have looked at the case, he has no claim to the shares in the corporation, whether because he never had a right to it in the first place, such that there was no issue of waiving it, or he has no claim of support within Jewish law. It's the wife who gets support from the husband after the marriage and not vice versa. So the answer seems to me is that he has no claim to the shares of the Schmata company.
I want to thank both of you very much. I enjoyed the papers, and I enjoyed the time up here with you. I'd like to talk to you for a few moments about the next stage of the proceedings. We seek feedback from everybody when we do this thing. And what everybody's always asked me to do is to have more time to actually speak to the panelists. So what I'd like to have all the presenters come up now to sit here at the table. Judge JUDY will chair, and we're going to take questions. So if you guys can come up, please.
Oh.
I think I'll just open the floor to a question. I'll try to repeat it so that people can hear. Oh, there's a microphone here. So if you have a question, come on up and we'll try to dole them out.
A two-part question. First, with the son being a lawyer and drafting the prenuptial agreement and protecting his interests, wouldn't that be a conflict of interest? And the second part, if it wouldn't be a conflict of interest, would the contract have the doctrine of contra preferentum to be held against it when it's interpreted later on?
Great, thank you. Judy, do you mind just speaking into the mic?
Yeah, sure. I think there probably would be a problem with the son having drafted the contract. I think that certainly it raised a concern that he was drafting it for his own interest, but I'm not sure how much of a difference it would make if he drafted it versus he had retained a lawyer for the mother and had somebody he retained draft it. I think either way there were serious problems with this contract that were there regardless of who drafted it.
Other questions? While we're waiting, I just wanted to come on up to the front. What do you do as a lawyer who's confronted with a client who came to you and said, my mom's getting married, she wants to do a marriage contract, or even the mom comes to you and we're getting married next week? How do you deal with that?
So what I would say is actually we have in our firm, we have a protocol. We call it the marriage contract protocol. And there are 3 things that have to be there in order for us to take the retainer. The first is that the marriage cannot be less than 4 months away. And if the marriage it's going to be in a shorter period of time, then we will not take the contract. We will actually do something called a standstill agreement. And that's essentially a contract that takes them through the marriage, but for a short period of time. If there isn't one signed after that, then it becomes null and void. So that's number 1. Our second protocol also is that both parties have to actually retain lawyers before the active negotiation of the marriage contract. So that avoids the issue of somebody handing a marriage contract to the other person, then running to try to get independent legal advice. We want both lawyers involved in this, so nobody can suggest that one party drafted it to the disadvantage of the other party. So that's an important protocol that we do. And then our third protocol is the full financial disclosure. And we also say that there has to be full financial disclosure prior to the active negotiation creation of the marriage contract also, and that also avoids the issues of non-disclosure or last-minute disclosure. Before it actually gets drafted, each party knows what the other one has, and if we don't have any of those, then we just don't take the retainer, because it's not going to stand up, especially financial disclosure these days are at such a high level that it's just not worth it to the parties.
Thank you. Sir?
Yes, I have a question on the ruling of the judge.
Is it an appeal?
Yes, this is an appeal. Which is, you ruled to set aside the domestic contract, I believe?
I did, yes.
Right. Therefore, Schmier would be able to take under the FLA, presumably. If so, based on the increase in value, he would get something, I'm estimating in the area of $5 million. And if so, would that not eliminate the claim under the support?
Sure.
And finally, there was in the facts the question of him making that claim within 6 months.
Right.
So are you allowing the extension of the 6-month time period?
Fair enough. I'm going to ask Charles to address the issue of the interaction between an equalization payment. Assuming there was an equalization payment, does that sort of get rid of the dependent support claim, or can they coexist? And I agreed to extend the limitation period to allow such an election.
It's a very interesting question. I think that a court is going to take into account everything that the interplay between all the assets and all the claims. Often you'll see the application, the request that the family law application be stayed until the completion of the Succession Law Reform Act claim. But I think at the end of the day, a court's going to have to take into account all the claims. Because certainly if a man has, or if the surviving spouse has a greater amount of money based on the family law claim, his need for support is going to be diminished. I think you'll agree with me that one of the factors that goes into a Succession Law Reform Act claim is that the state doesn't want to have to take responsibility for a dependent when that's something that the family should take responsibility for. If the family has taken that responsibility by virtue of a family law claim, that's going to be an important factor to be taken into account.
Questions? Other questions?
Jordy, I have one question for you. The witness talked about an oral giving over of the assets. Could you go over your consideration of that in light of Section 13 of the Evidence Act?
Well, I considered it very carefully. So I'll just jump in, and maybe one of the other participants can jump in on the idea of gifting. So you guys figure out among yourselves who's going to answer that. But Section 13 of the Evidence Act talks about the need for corroboration. And you can't simply make a claim against an estate for some event and rely simply on your own evidence. There has to be some other corroboration of that evidence. And so the issue would have been, you know, did we only have Irwin as the only person to give evidence? Now, there's documentary evidence there of the existence of the signed share certificate and other things. That would be corroboration as well. It doesn't have to be oral testimony. It's just that you cannot basically rely only on the evidence of one person. Anybody want to deal with who dealt with the transfer of shares? Kreger, did you deal with that, or delivery?
Well, from my standpoint, we just took it that the actual delivery would have been in accordance with what would have been required from a commercial transaction. So as a litigator, I wouldn't be a part of that. I would have someone who would regularly be involved in the transfer of shares, being looked after what would be necessary aside from the physical aspect of the shares, but what other paperwork would be signed. But the agreed statement of facts said they signed paperwork.
Right.
So.
Right. Archie, did you have any comments on the issue of the transfer and what kind of evidence you would want to bring to the court? I mean, we obviously just do a sketch here, but what kind of evidence would you have gathered, if you could, to deal with that claim?
I would have just approached it in the manner in the way I did. I mean, I did it without instructions, obviously, but I would have spoken to the applicant and recommended that we not make a play for the family business, for the share business, notwithstanding the evidence of REA that he also didn't have an interest, a long-term interest in the Schmutta business, only because my experience is the judges are reluctant to bring a short-term stranger into a family business when there is that human element that Mr. Schmutta, prior to his death, had built it up, and there was evidence of the sweat and tears and how they loved polyester and shutness and all that stuff. So I deliberately was avoiding making that play and came out early in saying that on behalf of the applicant that he wasn't making a play for those shares. If, on the other hand, the madman client would have said, I don't care what, I don't want the money, I want the shares, that would have been a different scenario, and I would have been then under a mandate really to secure whatever evidence I could. Minute books, for example. Who's signing off on the financial statements? Is there a change in control? What was reported to CRA? The point that you had made about if it's for estate planning, isn't it really just a beneficial ownership being maintained in the hands of Yenta? But if the accountants and if there are representations to third parties, there are so many cases where judges have dumped on counsel and their clients for saying, we have no patience for you taking one position with Her Majesty and another position in court. So I would have been very careful about not maintaining an inconsistency.
Thank you, Archie.
Just a question for WYNN HARVEY. With respect to the lifestyle reports, what's the range of cost that you find these reports? And also, how do you account for cash expenses, or do you account for cash expenses?
Yeah, so that's what I was actually trying to demonstrate when we were talking about the gambling and the pedicures and manicures. So generally, it's fee advisory, and we charge $3.50 an hour for myself and $2.20 for an associate. You're usually looking at the amount of time involved to analyze 2 years' worth of financial information and then running the numbers, usually between $15,000 to $20,000. Your last question was about cash allocation. When I do a lot of interviewing with the client, and we actually go through and walk through what is it that you spend in cash. And I did one recently where there was a heavy amount of cash, and we had to go through a lot of details and also get follow-up receipts where they hadn't been collecting them. So does that answer everything?
Thank you.
Thank you.
Any other questions?
The agreements talks about full and fair financial disclosure and all these prenuptial agreements. What about other disclosure? For example, disclosure of liabilities that may affect a person's income. If a person had a criminal record, for example. If, for example, entering into a marriage, one of the parties had a terminal illness that they hadn't disclosed to the other party. And let's say you said, well, if we're together for 5 years, you will get X dollars on my death, but knowing at the time you weren't going to live 5 years. Would that invalidate the contract?
That's an interesting question. Generally, we are talking about financial disclosure, and that would include liability. So, and in fact, the section of the Family Law Act talks about significant assets and liabilities. So to the extent that somebody didn't disclose a liability, a significant one, that would be an issue in terms of the contract. In terms of not disclosing an illness, that might impact it. I'm not sure whether that would or wouldn't. I guess it would depend. I mean, I would think that if you have a regime, sometimes we do put into these contracts, which I think you're talking about, if we're married X years, you get this amount, Y years. I'm not sure that the fact that somebody knew they were ill or not would really impact that, because potentially based on that, you would have the assumption that somebody could perhaps pass away the very next day, and the person would have no entitlement to support whatsoever. And in fact, when I'm advising my clients, and if we set up something like that, I do certainly say to them, you know, if the person dies in 6 months and your support kicks in a year, you're not going to get anything, or you're only going to get this after a year. But the reality is, certainly in terms of family law, and I'm not sure under the Succession Law Reform Act, I'm not really dealing there, but when we deal with support entitlements, generally if a person's only been married 6 months or a year, we're not looking at huge entitlements, because it's going to be a marriage of a very short duration anyway. So even if somebody didn't know, and even if the person passed away in a very short period of time, and I am not sure that that would really have any impact, or that's a consideration. I haven't actually looked into it. I haven't seen any case law about it, so I don't actually know. I know that we're generally talking about financial disclosure. I don't know if anybody has a different understanding of it.
So I think, unless there's anybody else has a question, I think that about finishes up the question section.